All right, the next matter on calendar for argument is John Doe versus Regents of the University of California, case number 20-55831. Each side has 10 minutes. So I don't know, okay, I see both of you. Can both of you stay on with your picture during the argument? Not that I noticed some people were flipping off, and I'm used to seeing both of you. In case either of you are making faces, I'll be able to see whether you're making faces or not. But
there will be no sighing and no faces. I'll keep my camera on.
Thank you. Oftentimes we can look out into the audience, and I see people nodding and going their heads back and forth, and so sometimes. But yeah, I would we like to try to make it as close to what court would look like. So thank you both for staying on. Okay, so we'll start with the appellant in this matter.
May it please the court, Mark Hathaway for appellant and plaintiff. I intend to briefly address three issues, respond to questions, and aspirationally, I'd like to reserve 2 minutes for rebuttal.
I have a lot of questions, so I suspect you'll get your 3 minutes, but I suspect I have quite a few questions of you. So go ahead.
Thank you. First, should the court decide that plaintiff's allegations are not sufficient to raise a plausible inference, plaintiff requests the opportunity to amend in light of Schweik versus Arizona Board of Regents. Plaintiff did have the opportunity to amend before that case was decided, but should be permitted to amend in light of that. Second point, I just want to connect the dots between Regents Appendix E, which is Exhibit A of its motion for judicial notice. Appendix E is part of the process that was implemented in 2016 directly in response to the social political movement that's inescapably gender-based to address the rape culture on college campuses. And Regents continues that same process today. From 1970 until 2016, misconduct was addressed by PACOS 100. There's a simple 1/2 page. It's addressed on page 20 to 22 of the reply brief. But the PACOS policy has procedural due process, describes the entire process in about 1/2 page. After January 2016, in response to the social, political, gender-based movement, Regents implemented this 2016 Appendix E. That has links in it. The links still work in the Appendix E file with the court. That links to the SVSH policy, the sexual violence and sexual harassment policy, and then also to PACOS 100. And this shows that the UC instituted essentially a gender-based judicial system, eliminated the due process from its simple PACOS 100 policy that's about 1/2 page, and implemented, sometimes it's been over 100 pages, now it's 88 pages of policies regarding sexual misconduct where the accused students are invariably male, which is
let me ask you this. So I have a couple of questions about John Doe here. Where is he now, and what happened to him as a result of this?
After this, John Doe is happily married and is progressing with, I believe, with some research. He's no longer at the University of California. He lost that position, but
wasn't he in the middle of a PhD program that he got kicked out of?
Yes, he was.
So he did not finish his PhD at UC?
That's correct. I do not believe so, Your Honor.
Did he get deported?
He was not deported because of a green card possibility, because of marriage made possible by California and other states recognizing same-sex marriage.
Okay, so when he got banned from the campus and he got suspended, he lost his visa, right?
He did lose his visa. He lose the visa within about 30 days because there's a list that the university produces to the immigration, and he was off.
So I just have all right. My understanding of what happened here is Roe showed up unannounced on the day of the incident, and that they were going to meet later, but she shows unannounced. He had a class to teach, and then there is him trying to get to the class. Okay, and then when he comes out of the class, he gets arrested. Do you know? Obviously, and those are campus police that arrest him. Is that?
Yes, campus police.
All right. So I'm just going back to, I have a lot of criminal law experience. I was a public defender for a while, and then I was a prosecutor for 10 and a half years. It appears that there was a misdemeanor not committed in their presence. How did they arrest him? What was their authority to arrest him?
I can't address that. I believe that's correct. I believe Your Honor is correct. Misdemeanor and out of their presence.
Well, now there can be a citizen's arrest, but do we know if they arrested him before they even talked to him? Correct. So there's a period of time. He taught an hour class, so there's probably somewhere between an hour and 2 hours, and he gets arrested when he comes out.
Yes, and that would have been fully developed in the administrative record had the writ matter proceeded beyond the stay that was issued by Judge Chalfant for lack of evidence of any of an injury.
Well, she alleged not then, but later that she had a cracked rib or something, but then there was no evidence of that. So there seems to be a difference in terms of the university says that their confessing error has nothing to do with that there was no evidence or there was no there to their case. But the judge had said, but you take a different view on that. Can you explain that to me?
The different view is the court granted Judge Chalfant, Superior Court, Department 85, I believe. He instituted a stay because the petitioner, plaintiff, John Doe, had a likelihood of success on the merits. The issue that was focused on in the stay was the lack of any injury or lack of evidence of an injury that would support the finding that the Regents reached through the appeal process. And after that, the Regents confessed judgment, as they often or frequently do in such cases when challenged with the unfairness or the lack of evidentiary support. Under 1029.4, the court only reviews for fairness of the process and for substantial evidence or for evidentiary support. And based upon the stay ruling, the Regents decided to confess judgment, have judgment entered against them. The judgment would not normally include or ever include findings of fact, merely in order to set aside their decision. And Regents took no further action, administrative action.
So everything they didn't, the only thing that was left was I'm going to call it the altercation, the kerfuffle or whatever outside the office. Now, I saw in the record, there was some statements to the effect of, they've never known a woman to lie on this. Hypothetically, let's assume that a man showed up at a woman professor's place of business and caused a scene outside the office. Would anyone think that the professor would get arrested as opposed to the person that caused the problem outside the office? Was that ever considered in this process? Was that ever discussed?
I believe that would be best responded by the Regents, but I take the court, Judge Callahan, your point that, and I think we raise it in our opening brief and perhaps in the reply brief, that had the genders been reversed, Jasmine Rush would never had told him, he should have invited her in, for instance. But
she's not named, right?
She is not named, but in the That's correct. She's not a defendant in this action, but it's part of the record. And it's not just the kerfuffle at the door. Jane Roe was making 13 other allegations, none of which were shown to be supported. And those allegations were part of this long Title IX investigation process concerning a student that it was not a student. It was unrelated and should not have even been investigated under Title IX.
So go ahead, Judge Ammon.
No, I was just going to say, but your adversary would argue that that's part of the reason that shows that there is no bias, because they didn't accept everything that the complainant had stated, but they argue that shows the fairness of the process. Yeah, what is your response to that?
The problem is when you know somebody's lying about some things, can you pick and choose? And it shows how arbitrary it is to pick and choose, especially when there was video and there's no evidence of any injury. And in fact, they changed the wording from serious. They took the word serious out because there is no serious injury to just say injury. So it's not an indication that they were fair. It was an indication that they had to catch him on something. And no matter what they caught him on, they could have imposed a 2-year suspension, whether it's 13 things or whether it's one thing. So it's not, oh, we got this one right, but we got 12 of the 13 right. Maybe we got this one wrong, but we're fair. It should never have been investigated to begin with. She was not a student. It doesn't fall under Title IX.
Let me ask. Go ahead.
But she did complain about some things that occurred when she was a student, correct? So there were allegations that pertained to her at a point in time where she was a student, correct?
Yes, correct. None of which were substantiated and were all false.
But that was a basis for the investigation. You're saying they shouldn't have investigated it at all. That was a basis for the investigation too, correct?
No, federal regulations state that the school, in order to comply with Title IX, has to address or remedy hostile environments on campus. At that point, she's not on campus. There's no hostile environment for them to remedy. There was already the law enforcement in a criminal case. The civil courts and criminal courts can take care of that issue. The Title IX, it only authorizes the university to address a hostile environment on campus, which didn't exist. The
encounter outside of his office was a hostile situation on campus at the time it happened, correct?
Right, but if she's departed and it was caused by her being on campus, which she shouldn't have been, not caused by him, and there was no continuing hostile environment. If it's a one-off kerfuffle that resulted in none of the elements that the university could rely upon to find responsibility under Title IX, then it shouldn't have gone forward. The university is not faulted for starting an investigation, but the investigation at some point should have been dropped. And certainly, when there was no evidentiary support for the finding of a serious bodily injury, that should have been the end of it. You have lawyers from the university almost at every step of the way. We're not talking about people that are, they're professionals involved in investigation. They hired an outside lawyer to work to be the hearing officer, and all of those people just went forward with, he's responsible. He's gone for 2 years. We don't care if that's his expulsion. We don't care if that's the end of his PhD, because even in the absence of a factual and evidentiary support.
I understand part of your pleading to be that one of the people in the investigation told John Doe that he should have invited her in his office, that could have solved the problem of having something a disturbance outside the office. Are you arguing that if the roles were reversed, that if it were a woman, that you should invite a man into your office that shows up not blocking you to go to your class, that is that part of it? I'm trying to understand your argument.
It's not. None of these are in isolation. They're all taken in. You can't pick any one of them and say, well, that's not an indication. You could find an excuse for each of them. But in this case, Jasmine Rush's comment was, one is, I can't imagine that an irate male showing up outside of a female's office, that the resolution for that is to go into private in the office where there's no witnesses, where there's no camera. Here there was a camera in the hallway, and that the female should address the irate male under those circumstances. That would be an unreasonable presumption. And so Jasmine Rush's comment is just essentially tone deaf in a way on gender, because if you reverse the roles in many of these circumstances, you get a completely different result.
Well, is it your view that comment is evidence of gender bias? That's what you have to show here.
Well, what we have to show is statements or allegations that raise a plausible inference that the university's motivation for continuing its action against John Doe was motivated by gender, and it clearly was. The entire process is part of a social political movement.
I want to ask you about that, because I think you've got a lot of allegations in the complaint that show that the procedures are set up to favor the accuser in this kind of a context. But sort of following up on what Judge Ammon's point is while you show that there's a favoring of the accuser, I'm not sure that they always have a connection to gender. Because they're favoring the accuser, they're necessarily favoring the women. So what about your allegations make that link?
Well, one is there's absolutely no mention anywhere in the UC Regents' efforts to address the rape culture of male victimization. The CDC reports that at least about 25% of males suffer sexual assaults.
So, okay.
There's other, but you can't have it
do with that
just
because
based on one gender.
Counsel, I'm not sure what to do with that part of the context that you've relied on, because this isn't a sexual violence case. So what do we do with all of this context about campus rape when this isn't one of those cases?
Then how is it even gender-based? How is it even gender-based between Roe and Doe, other than they happen to be male and female?
Well, that's my question to you. That's my question to you, exactly.
So then if they were both male, would you have the same result here? No, you would have a male. No, I don't believe so. It's because the accused is male and the accuser, the complainant, is female. And I think we've laid out fairly clearly as we could at the time a series of allegations that show that there's a reasonable inference. I mean, there's some 700 cases or more across the country of males challenging the unfairness in these processes because there's a reasonable inference that the action by the universities is based on gender. And there's the lack of any kind of discussion about male victimization, no resources for male victims. All victims are survivors, female survivors. There's generally no gender diversification in the entire Title IX process.
Let me ask you a question here, though. Getting to your client's case, are you arguing that the university here didn't follow their own procedures? Because you claim that he wasn't allowed to speak during the appeal process. Was that in violation of some procedure, or is it your position that all of their procedures are against men, so that's the end of it?
No, that's not our position. But
it seemed to be what you were saying, because you said that all of the procedures that they have developed are all as a result of this anti-male culture. So I heard you to say that all of the procedures favor females over males. But the question here is, are you arguing that in your client's specific case, there was some procedural irregularity, that they didn't follow their own procedures, which gives rise to some evidence of bias?
They didn't follow their own procedures in providing equal access to the evidence. evidence was redacted. There was no cross-examination. The 2016 policy that they implemented and that they enforced was found to be lacking in due process and fundamentally flawed, which required them to change their policies. So, of course,
their policies changed at the time. In other words, at the time of his hearing, were they following their policies, or were they not? Whatever you think about the policies, were they following those policies or not following those policies?
Not following those policies. For instance,
in what way?
Well, Appendix E says that the parties have the right to see the investigation file, which would be all the information collected in the investigation. I don't believe that occurred here. And again, I don't think these issues are before the court. They would have been before the court in the writ of mandate process about the fairness of the process. But they did not comply. They did not provide all the evidence. Information was redacted. He wasn't allowed to speak. So there's under the PACOS 100, you get a fair hearing with the right to speak where the university bears the burden of proof, and you have a right of cross-examination and the ability to present evidence. What happens here is that there's no de novo hearing. There's no evidentiary hearing. The decision was already made in secret, no cross-examination, no, you have individuals deciding credibility.
The process at the time, and I know you argue about the process, but was that the process that was in effect at the time?
No, they should have allowed him to have access to the evidence. There was no reason to redact. There's no mention in the policy about withholding evidence. What they do, what happens is because there's 88 or 100 pages of interwoven policies, there's no clear right that where the university, a student can say, I have the right to see the evidence, other than they have the right to see the investigation file. Then the university says, well, that only includes the information that we believe is relevant, so that they can exclude any exculpatory evidence. That has been reversed because of court litigation. So and their reliance upon credibility assessments made by non-professional investigators who never met the witness. That didn't really occur in this case.
I guess, Mr. Hathaway, I guess what, in response to what Judge Ammon is saying, is, are you also, all right, you're saying that the process was gender-based at the time, and that there's evidence that the fact that they changed it later, that it wasn't a fair process. Is that what you're saying? And then you're also saying they didn't follow the process? Or I'm trying to drill down on what.
They did not comply with their own process, and they did not comply with due process, even if they had complied with their policy. So that the student is left with fighting for what he should receive under the policy, whether or not that's deficient, which has been found to be deficient, lacking in due process. And then one has to wonder, why is there a completely separate, complicated rules for adjudicating one form of misconduct that takes away the procedural due process that's in the very simple process, except it's entirely based on gender. It's motivated by, and that. Let me ask you this, and
then we've gone way over time, but I want to have all our questions answered. Did your client, was he ever charged by the DA?
I do not know, Your Honor. I did not handle that portion of it, and I believe so. I do not know the outcome.
Okay. All right. If the judges don't have any additional questions, you've had 13 more minutes already, so I'm going to go to the other side.
Thank you, Your Honor.
Forrester, Judge Ammon, do you want to ask any questions right now? I'm going to give him some rebuttal time.
Thank you.
Thanks. Okay. Ms. Chen.
Good morning, Your Honors. Hyland Chen on behalf of Appali, the Regents of the University of California. First, I'd like to address the reasons why plaintiff's allegations fail to support any plausible inference of gender discrimination. And then I'd like to address some of opposing counsel's specific arguments, because there is some fast and loose arguments about what is actually in the complaint and what is not. There were a lot of arguments raised just now that were never alleged in the complaint.
All right. Well, I think what he's saying about that is those are things that he would ask for leave to amend if, and after the Schwacky or Schwakey or however we say that case.
Understood, Your Honor. Plaintiff's case here is unlike Schwakey or any of the other cases from other circuits because he was provided with a meaningful opportunity to be heard. And that is clear from his own allegations. He had
I need to take you back to how this started. I am very troubled by the fact, and this probably is my extensive background in criminal law, that when someone shows up at someone's place of employment and takes the fight to that person, apparently they were going to meet later that day, but she came then. I don't know whether she knew he had a class or whatever. She clearly doesn't want him to go teach that class and causes a scene at your place of employment. In my experience, assuming that because she's a woman, something must have happened to her when she took the fight to him is I don't want police officers coming out and making a decision that someone's a woman or a man. I mean, one of the first things you think is who went and started the fight? And she went and started the fight that day. Was that ever, I don't understand how then he gets arrested when he comes out of his class.
So this
who ordered that arrest? Who ordered that arrest?
The university police, according to plaintiff's own allegations, it was the police who effected the arrest. It was not a citizen's arrest.
But how can they, but wait, how can they, I'm just going back to, police can't arrest someone for a misdemeanor not committed in their presence. Have you heard that before?
I have. And the California Penal Code provision that applies says that police can effect a misdemeanor arrest for domestic battery. This involved an ex-fiance, ex-boyfriend, and this falls within the definition of that provision, that they can effect that arrest when there's probable cause. Now,
does there have to be some injury? I mean, generally there's injury involved in those situations.
So there has to be physical touching. And that's what happened. This was more than just a verbal altercation. And I take Your Honor's point about she goes to his office, she engages in a kerfuffle, she argued. But this was more than just a verbal altercation. This involved battery. Sworn peace officers arrived on the scene and effected an arrest. Now, Mr. Hathaway,
they didn't see the situation. Did they watch a video before they arrested him?
It's not clear from the allegations in the complaint whether they did, but the complaint alleges in paragraph 25 that there was a graduate student present in plaintiff's office at the time. This is not a situation where there were no plaintiffs. And indeed, the Title IX investigator did interview witnesses. So police officers found probable cause.
The Title IX investigator didn't find that there was, in fact, an injury, though. The hearing, it only came to a finding that she feared an injury. There was no finding that she was injured in any way, correct?
That's correct, Your Honor. So we're talking about two different points in time. One, when the police arrived on the scene, they did find probable cause to effect an arrest. Ultimately, at the end of the day, following the whole Title IX investigation and adjudication process, he was found responsible for putting her in reasonable fear of serious bodily harm. And so it did not result in a finding of physical injury. It was fear of bodily harm.
And that's something she had lied about, correct? Because she claimed to you and to the police that she had bruised her rib or had an injury. So the university knows that she's not being candid, yet they still take her word over his word, correct?
So I would urge the court to look very carefully at the allegations in the complaint, because opposing counsel has stretched those allegations beyond what is actually in the four corners of the First Amendment complaint. What is alleged is that she claimed she suffered a rib fracture. The police came and took photos, and those photos showed no bodily injury. Now, there's no allegation that there were x-rays taken that revealed no rib fracture.
Well, at some point there was later. She had x-rays taken, right?
It's not clear from the allegations in the complaint whether that occurred. And at the end of the day, this is not a situation where the university simply took complainant's word for it because she was a woman and rejected plaintiff's word for it because he was a man.
All right, but we're at the pleading stage. We're at the pleading stage. And there's some other allegations. You have some people saying, well, we've never had a case where a woman has lied. What do you do with that? What do you do with that? That going into it, you have to presume things at this point because it's not a trial. That do you want to go into a hearing when the thought process is, well, we've never known a woman to lie. I actually know people. I know men that have been killed by women in cases that I'm aware of as far as that goes. So it does happen. I mean, but if your mindset is that women never lie going into it, why isn't that a problem for you at this stage in the proceedings?
It's not a problem because there is no allegation that that person who made that statement had any influence over the process. Unlike in Schwakey, where the professor's statement was made in the context of the ongoing disciplinary proceeding, in a context where there were witnesses.
Well, so he's going to argue you had things on campus about male toxicity. You had all this training, and I'm older than you are, and I've gone through the time where when people never believed a woman that she was sexually assaulted, and universities didn't investigate those things, and so then you're in the aftermath. What he's arguing is then the aftermath goes completely the other way, but either way, men and women should be able to be evaluated on their own and not based on some gender assumptions.
Well,
all women don't tell the truth. All men aren't abusers. Some men are, some men aren't. Mr. Doe could be a huge jerk, but Title IX is not in the process of adjudicating whether you're a jerk or not. It's in the process of it addresses other issues. So, and then he's saying, and then you go full bore on this, and she's not even a student at the time. So why isn't all of that enough together to get past the pleading stage?
Because at the end of the day, Doe was found not responsible for 90% of the allegations.
Do you think he feels good about, he was found not responsible for 90%. He still got the same punishment, even after you went on a writ and the judge said, hey, you got nothing here. You got to go back. Then you modify it and you still say, oh, but we got this little piece and we're still going to give you the same punishment. Wouldn't he like to say that to a jury? I think he probably would.
There is no indication that.
I mean, if I get acquitted of 5 murders, but I get found guilty of 1 murder, do I get the same sentence? He got the same sentence here, right?
It's not clear that he.
Well, the 2 years, he got you gave him the 2 years.
The 2 years was the mandatory minimum under the university's own policy for the conduct violation that was found here. And even though all of them, are you saying it had to be, even though she had no injuries, and I guess he looked mean at her and it scared her, that's what you finally cling on after everything else gets thrown out of, you still had to give 2 years? When a student is found responsible for placing another in fear of serious bodily injury, that is what the policy requires as the discipline.
Finding was that it was only fear of injury, not fear of serious injury. And isn't that a distinction?
I believe that quote was from some statement that the Dean of Students had made. The finding was that he had violated that particular provision of the Student Conduct Code.
After the state court proceeding and the stay, which I take it wiped out the sanctions, what happened after that? Did you have another hearing? Did you reimpose the sanctions? What happened after that?
So the stay did not wipe out the sanctions. What the stay did was stay the interim suspension. And that then allowed Doe to continue to come back on campus and the like. What then happened was, as is alleged in the complaint, a confession of judgment. And as Mr. Hathaway acknowledged, that is something the university does routinely. It is not an indication that the university was biased against him.
Did you seek to suspend him again, or was he not suspended as a result of the state court action? In other words, you heard they banned the interim suspension. Did you then proceed with additional proceedings and suspend him again, or was that the end of it?
That was the end of it. By the time the case was returned to the university by the issuance of the writ, the university exercised its discretion as it is allowed to when such a writ is issued and declined to proceed with any further proceedings against him. That's quite common in these student conduct cases when a suspension by that time most of it has been served. There's lots of different factors that the university weighs. Again, what happened after the writ returned the case to the university, however, that's not alleged anywhere in the complaint. And as this court noted in Schwakey, when something's not in the four corners of the complaint, it shouldn't be considered. In Schwakey, the court noted that the Dear Colleague letter of 2011 was relevant, but declined.
So you did nothing after the writ. After that, you did nothing against him.
The university did not take any further disciplinary actions against him after the writ returned the case to the university.
But you left the suspension, but he still has a suspension on his record, doesn't he?
No, the writ eliminated the suspension, and a suspension.
But it doesn't eliminate the charge, right?
There is no longer any disciplinary matter against him. It eliminates the charge. It eliminates the suspension. It's not.
So has he been exonerated?
I don't know that there's such a procedure as exoneration, Your Honor. What the writ commanded the university to do was to vacate the findings and sanction against him, which is what the university did.
Well, but because the judge said you had nothing, right? It wasn't supported what you did.
So I think we're mixing a couple of things.
Well, I know it's not law of the case, but when we're talking about knocking something out at the pleading stages, I'm asking you questions that I have concerned about here. You have another judge that looked at it and has concerns. So you don't need a lot to get past the pleadings here. So there's...
Understood, Your Honor. The judge in the Superior Court in imposing the stay was not considering the merits of the case. Was just
he had to. Didn't he have to? The likelihood of success? You have to, don't you?
And those things go to things like, at the time, there was a big question in the California Courts of Appeal as to whether a person in plaintiff's position was entitled to live cross-examination of the complainant in front of a neutral fact finder. There's all sorts of reasons that are unrelated to gender bias as to why the judge could have found likelihood of success on the merits. The judge ultimately, in issuing the writ, reached no decision as to whether the university did anything wrong or not. It was simply a device that allowed
the Title IX process that you had in place with John Doe. You've since changed that?
Yes, and that is in response to changing federal regulations. For example, federal regulations were changed such that universities in August of 2020 had to implement new policies and procedures, including ones that go to what Mr. Hathaway talked about, when a complainant is not a student. That did not apply back when this incident occurred. That went into effect in August 2020, and by its own terms, the regulation are not retroactive. So yes, the university...
So you're not in violation there, but I see an argument to say it wasn't really a very fair procedure, and that's why we've sort of evolved on these things. That if there were a lot of challenges to Title IX processes, and there was a lot of challenges that they were sort of kangaroo courts, and they just, without any process, took serious action against students, and they've been changed. So while he can't claim a violation against that, but that was what was going on back then. And if subsequently it's been determined that those processes didn't give women and men equal access, isn't that something he can allege?
It's not enough to raise a plausible inference of discrimination on the basis of gender. And both the Sixth Circuit in Doe v. Cummins and the 10th Circuit in Doe v. University of Denver have made clear that these sorts of due process issues are deficiencies that at most show a disciplinary system that is biased in favor of alleged victims, who can be men or women, and against those accused of misconduct, which can be men or women.
So I want to go back to, Judge Callahan asked you a few minutes ago about a piece of evidence that definitely has a connection to gender, and it's this statement about no female, I think the quote is, no female has ever fabricated against an ex-boyfriend in a Title IX setting. That's the allegation in the complaint. And your response to that was, we shouldn't care too much because it wasn't made by the decision maker or somebody directly involved in this proceeding for this particular accused. I want to follow up on that because the allegation is that the statement was made by the university's respondent coordinator. My understanding is that that would be a person in the Title IX office that deals with the people who are accused, and that the statement was made by that person directly to the plaintiff. So how is it that if it's made by a university official whose job it is to assist people who are being accused in these processes, and it's made directly to the accused in this case, that that's not something we should consider as material?
So, Your Honor is correct that it was made by the Respondent Services Coordinator. That office is actually separate from the Title IX office. And the reason it should not be considered here is because there's no allegation that he had influence over the decision-making process or the outcome.
But he works there. He works there. You train those people. And if that's what they're saying, that women don't lie in abusive situations, why can't you make the logical inference from that is that's how you approach Title IX investigations?
That inference is not a reasonable one here because of what resulted. Complainant here, a woman, made a whole host of allegations against her ex-boyfriend. And rather than simply taking her word for it, because the decision makers believe that a woman never lies about her ex-boyfriend, the university carefully considered the evidence and in fact rejected 12 of her 13 allegations.
Was there any finding by the university that she was not credible?
I don't know from the allegations in the complaint whether there was a finding. There's not an allegation that she was found not credible.
Because couldn't the explanation for why the university didn't go forward with every allegation that she made is that they just felt like, don't have enough evidence. We couldn't actually prove it. And it wouldn't necessarily mean that they're saying that they think that she's lying. You see the point that I'm making?
Yes, I understand that distinction, and it is entirely possible that could have been the basis for the findings that those 12 allegations were not substantiated. It could have been.
I guess I'm struggling with, yes, it could be an explanation, but then on the other hand, she lied about the ribs. They could have said, hey, and then you modify, you whittle it down to the tiniest little possible thing left so that you can, if I were on the other side, I would argue, well, you're trying to save your, you had all of this going on and it comes down to one tiny thing and you want to somehow justify, well, something must have happened because we have to somehow justify that we suspended this guy for 2 years, even though, and then you end up in court and that judge says, hey, where's the beef? And then you go, oh, well, it's almost 2 years now, no big deal. And someone said, well, let's just stop it now. But there's a big giant world of it. And it's down to a kernel of that she herself felt in fear or felt, but no injury, all of that, everything. It just came down to nothing. And he served 2 years of a suspension, right?
I'm not sure what's alleged in the complaint shows that he served 2 years of a suspension.
He didn't get paid. He didn't finish his PhD there, right? He was suspended. He lost his visa. If there's no truth to any of it and you should have done a better job, that's a pretty big lawsuit against the university. So it's good if you just have one little charge left. That's what he's going to say. There's two ways you can look at it. You're saying, well, we did such a good job that we figured out that she really couldn't prove everything except there's one little thing left.
Understood, Your Honor. At the end of the day, though, he was given a meaningful opportunity to be heard. The allegations here are nowhere close to the ones alleged in Schwakey or in.
Well, do you think he should write you a thank you note? He should write you a thank you note for everything that happened to him?
Absolutely not, Your Honor, but it doesn't meet the standard of a plausible inference of gender bias.
Counsel, I have a follow-up on that because there's another allegation in the complaint that causes me some significant concern in terms of your position. And that is the allegation that the university has never suspended a woman for 2 years for any sort of dating violence situation like the character of this circumstance. So we're at the pleading stage. Don't we have to accept that as true? And if we do, doesn't that have a connection to gender discrimination as opposed to just, favoring the accused?
I believe that is, yes. I believe that is an allegation that is made on belief only. There are a number of allegations in the complaint of that nature that are made on belief only. This court has held that such allegations on information and belief need not be accepted. And there's no explanation for the basis of that allegation. Certainly, it's true that at this point at the pleading stage, one only has access to so much information. But again,
who has all the Title IX records? Who has all the cases? Because if you knock it out at the pleading, I mean, there are people that may have, you're saying, well, it's anecdotal, but I think what Judge Forrest is saying, we're at the pleading stage, and if we cut people off at the knees there, they don't get to do any discovery and actually look at your records, and maybe your records would show that.
And also, I'm looking at paragraph 117 of the complaint, and it's not based on information of belief. It's an assertion. The university has never suspended a female for 2 years based upon these same circumstances. I mean, that's making a connection to gender bias.
That is
also supported by, isn't that inferentially supported by the statement of Jason Zeck that no female has ever fabricated allegations against an ex-boyfriend?
Well, so taking the allegation in paragraph 117, I would point the court to the reasoning of this court in Austin. That simply that enforcement is asymmetrical says nothing about whether it is selectively so, and that there may be these sorts of asymmetries that are the result of things that have nothing to do with gender bias, that could have everything to do with, for example, who actually is committing assault. And so not only in Austin has this court decided that, but in numerous other decisions, courts have pointed out that if no woman has ever, we're at the pleading stage. That may be why you would win a trial. It might be why you would win at trial, but you're asking to win at the pleading stage. So plaintiff could have, but did not plead that women have actually been in these same circumstances. And given that,
how would he know that without discovery? How would he know that without discovery? They do make the allegations. You have all the Title IX records, right?
That's correct, Your Honor. There are also lots of things out in the public record. The California auditor has done a public audit. There's numerous documents out in the record, especially given that the University of California is a public agency subject to Public Records Act requests and media scrutiny. But plaintiff knew enough to apparently allege that the university has never suspended a female for 2 years based on similar circumstances. What he failed to bridge that gap, though, by saying that, and there was an imbalance in, there were actually women who were committing these sorts of incidents of misconduct.
Isn't that a matter of common? I don't know.
Go ahead, Forrest. No, go ahead. There's a lot of questions here. I think go ahead.
No,
okay.
I was making an argument, not a question, so never mind.
Okay. All right. So, Judge Ammon, do you have any questions?
No.
All right. Well, we've taken both of you over. I'm just going to give you 2 minutes for rebuttal. Okay. So that kind of evens up the things here. So we've taken a pretty deep dive here. So go ahead.
Thank you, Judge Callahan, and I thank all the judges for, obviously they're considered, this is an issue that goes beyond this particular plaintiff, but this plaintiff is just trying to get past the pleading stage and trying to get the discovery where he could establish the allegations that are alleged in his complaint. And I believe if you take them all in together and read them in context, it shows a plausible inference. I think most reasonable people would infer that the action taken by the university against him was motivated, at least in part, maybe not in whole, but based on his gender. I did want to point out that he was summarily, the interim suspension went into effect in it looks like February of 2017. The stay was issued in March of 2018. That's in the complaint. So he was suspended essentially for about a year, and the university took no further action. The training of the university does show forth in its.
If they took no further action, he still didn't get his job back, right? He lost his his position. He lost his job. He lost his PhD process. When you lose a year of it, he also lost his visa. He was able to remain in the United States, as I said before, and he remains here to this day. Continues with his life, but he's just trying to get back what was taken from him under his federal complaint for Title IX violations, and he's alleged the elements of those two issues. And if he hasn't under Schwake or Schwakey, then he should be allowed leave to amend if it's not sufficient, and so that he can get past this pleading stage.
What would you say leave to amend? What would he add?
Well, he would amend. The university puts forth experts, people with no PhD, as master's degrees, to testify in hearings that no woman ever lies about sexual misconduct. There's just so the court.
That's not in your complaint now?
It's not in our complaint now. No, there's other issues that have arisen since that time that could be alleged, and certainly it wasn't. Plaintiff wasn't aware at the time because Schwakey hadn't decided exactly, what else he could put in the complaint. But to cut off a plaintiff in these circumstances,
you make a motion to amend again that was denied. You didn't, correct?
We did not. No, but then Schwakey came out, and so we took the avenue of filing the appeal.
But
you could have also made it
is just an account of the law. Why does Schwakey's allegations wouldn't necessarily be the same as your allegations? I mean, whatever facts you had, that's not changed by Schwakey, is it?
Well, of course, it's modified by that because this district has adopted what was adopted by, I think, the 7th and 3rd districts, that this simplified pleading method makes much more sense. And that didn't occur.
That's a legal argument. I'm not understanding why you think Schwakey means that somehow you would have put additional facts in there that you had but didn't put in the complaint. That doesn't make sense to me. You may have asked for the argument, but it's a legal issue.
It does, because in Schwakey and other similar cases, it's not just the specific, the allegations of sort of, I would say, a institutional, I'll say bias or lack of partiality. It doesn't mean they're anti-male or anti-female or anti-any particular gender. It just means from the outset, there's a lack of impartiality where it's presumed that an accused is responsible and therefore doesn't require the procedural due process that every other form of misconduct
does. But you don't have a due process. You haven't appealed on due process. That was resolved on 11th Amendment grounds. You're just appealing here your Title IX. You don't have an extant due process claim, correct?
Correct, but I think it makes sense that where an institution, in this case the University of California, puts in processes that remove due process from accused students, and where there's no mention ever of any kind of male victimization, and it's all one-sided, that it's plausible that that's motivated in part based on gender, and that should be sufficient. So under Schwakey, there's additional factors that are not just related to this particular plaintiff that would help to overcome the burden to show a plausible inference that the university's actions against this particular plaintiff were motivated in part based on his gender. Thank you very much for your patience.
Thank you both for your helpful argument in this matter. This matter will be submitted as of this date. Thank you. Okay.
Thank you.